Hi Madam Shahila, my name is Divya Perumal and the topic that we choose is Trespass. Let me present the introduction. Trespass is a direct and international interference with another person, property which violate the person's right to enjoyment of the land, possession of goods and freedom of movement. Furthermore, trespass is an actionable proceed without proof of damage.
Assalamualaikum, my name is Nofata Najwa. I will explain for the next part. Crime versus Tort. Crime are identified by legal system as at a go against society like child abuse and domestic violence. Crime mostly happen due internationally and crime are tried in the criminal court. Compensation for crime has been mentioned in the law book. In crime, we use the beyond reasonable proof as a standard of proof. Punishment for crime is heavy and serious from death to fine. For the tort are based on injury to individual due negligence or personal damages. Tort mostly happen due negligence and are tried in the civil tort. The compensation is given on the basis of the damages to the aggrieved party. In tort, for the proof, we use preponderance of evidence as a standard of proof. Nature of remedy is like in the form of damages.
Hi and Assalamualaikum. I'm Nur Ali Natasha binti Muhammad Afendi and I will explain about why trespass is under English law. Basically, English law is under unwritten law. Unwritten law are law which are not contained in any statute and can be found in case decision. No law governing a particular circumstance. Malaysia case law may apply. If there's no Malaysia case law, English law may apply. So, why trespass is under English law? In Section 5 of Criminal Procedure Code state that English law should be applied if there's no specific legislation has been enacted. In context civil law, in Section 3 and 5 of Civil Act law allow for application English law, equity rules and statute of Malaysian case law, whereas there's no specific law has been made. So that's why trespass is under English law, because trespass not have any specific legislation has been enacted. But however, trespass is also covered by tort, not only by criminal law.
Assalamualaikum and hi to all my fellow classmates. My name is Noshakira Nikmat. My metric number is 41930035551. Today I'm going to present a few parts in the slides. I'm going to start with trespass to a person. What is trespass to a person? Trespass to a person means a direct or intentional interference with a person's body or liberty. There are 4 categories of trespass to a person, which are assault, battery, false imprisonment, and nervous shock. I will start with the first one, assault. What is assault? Assault is an intentional attempt using violence or physical force to injure, harm, abuse, or traumatize another person. There are a few actions that may be assault include. The first one is applying force. For example, kicking, hitting, or threatening to apply force. Next is trying to strangle or choke someone. Physically restraining someone, and the last one is using weapons such as knives or guns. Next, there are 3 levels of assaults. The first one is simple assault. Simple assault is occur when an individual applies intentional force to another person without the other person's consent, attempting or threatening by an act or gesture to apply force. The second one is committing an assault. When committing an assault, if the individual carries, uses, or threatens to use a weapon or causing bodily harm, the individual is guilty of assault, causing bodily harm. The last one is aggravated assault. Aggravated assault is committed when a person wounds, maims, disfigures, or endangers the life of the victim. Here there is intent to commit bodily harm. There are three elements of assault. Number one is an act or conduct intended to create it, a reasonable apprehension, and of imminent harm. For an act or conduct intended to create it is to prove a criminal attack. The defendant behaviors must be motivated to create a situation or danger in the victim's mind. Accident acts do not include allegation of assault. The second one is a reasonable apprehension. Further, the victim must reasonably believe that the defendant's conduct will harm or humiliate him. The victim must understand the defendant's potentially harmful or offensive acts. And the last one is of imminent harm. The victim's fear must be direct response to a threat that is imminent. Future threats such as "I will beat you tomorrow," "I will not result in assault charges. In addition, there must be some kind of perceived physical threat to the victim in the loss. For this reason, words by themselves generally do not constitute an attack. Defenses. As with other types of criminal charges, there may be some defenses to assault charges. This will depend on each individual case, as well as other factors such as state law. Faults commonly charged with assault charges include self-defense, intoxication, coercion, lack of proof. For the first one is self-defense. This could be a defense if the defendant was acting out of self-defense. They should only use the amount or display of force that is appropriate in the situation and in proportion to the force being used against them. Intoxication. In some cases, intoxication can be a legal defense, especially in cases where intoxication affects a person's ability to act intentionally. Coercion. This may be a defense if the defendant was forced to attack under threat of harm, for example, if they are being held at gunpoint, and for assault at the behest of someone. Last one is lack of proof or proof. As stated, if the elements of the proof are not found or supported with the correct evidence, it can serve a legal defense. Remedies. Action for damages. Whenever the plaintiff has been wrongfully detained, he can always bring an action to claim damages. Compensation may be claimed not only for injury to the liberty but also for disgrace and humiliation, which may be caused thereby. According to McGregor on damages, the details of how the damages work in false imprisonment are few. Generally, it is not pecuniary loss or of dignity and is left to the jury and their discretion. The principal heads for damage would appear to be the injury to the liberty. For example, the loss of time considered primarily from a non-pecuniary viewpoint, and the injury to feelings, for example, the dignity, mental suffering, disgrace, and humiliation with any attendant loss of social status. Next is self-help. This is the remedy which is available to a person who, while he is still under detention, instead of waiting for legal action and procuring his release thereby.
Battery is the intentional and direct application of any physical force to another person. It is the actual striking or even touching of another person in rude, angry, revengeful, or insolent manner. A battery occurs when someone touches another person without that person's permission. A battery is often confused with an assault, which is merely the act of threatening a battery or placing another in fear of impression of an impending and immediate battery. There are four elements of battery. First is intention to apply force. The intention to apply force is the person must have applied the force with intentionally. For example, we can look at Scott with Shepherd 773. The defendant threw a squid, which is a small leak, firework into the busy marketplace with a lot of people and stopped. In order to protect themselves and avoid damage, the squid was thrown on by two other people. Second element of battery is the act was under the control. The person act must have been voluntary. We can look at case given with paper 1695. The defendant was riding a horse when someone hit the horse from the behind, causing the horse to two board. The horse collided with plaintiff. The defendant was not liable as the act of the horse bolting and colliding with the plaintiff was outside the defendant's control. Third element of battery is use of force. Any physical contact with the body of the plaintiff or his clothing is sufficient to constitute Call-Viternal 7004. This has been interpreted to mean that contact with this thing attached to the person will only amount to battery if there is a transmission of force to the body of the plaintiff. Last but not least, element of battery is without consent. One cannot touch another person without his consent or without lawful justification. For this element, we can look at the case Chong Ping Chong v. Wang Xiu-byung 1664. The defendant was liable for battery for scratching the plaintiff's face and hitting the plaintiff due to her jealousy of plaintiff's friendship with her husband. There are five defense battery, which is necessity, consent, self-defense, defense of other, and defense to property. Consent may be available as a defense through a battery charge depending on the jurisdiction. Self-defense is probably the most common defense in assault and battery case. The defense of other is very similar to self-defense. This defense is trying to save another individual, not himself. The defense to property. A defendant in the battery case may be able to claim that they act only in defense of their property against being invaded or illegally withheld. Four remedies of battery. They have legal remedies, reactionary remedies, and equitable remedies. Legal remedies are also known as damages, which is compensation given by the defendant to the plaintiff to compensate for the injuries, pain, or the sufferings. The compensation is directly proportional to the victim's loss, not to that of the defendant's profits. For the restoration remedies, there are four types of restoration remedy, which is restoration damages, reclaimment, enchantment, and property lien. For lastly is equitable remedies. The equitable remedies have two types, which is temporary restraining order and temporary of permanent injunction.
Assalamualaikum warahmatullahi wabarakatuh, and good morning to Madam Shahila and to my fellow friends. My name is Nurul Izzati binti Muhammad Fauzi. I'm taking Bachelor of Accountancy, 21 years old, and my matrix number is 419300517D. Now, I will present my part, that is false imprisonment. False imprisonment is the third category in trespass to a person. False imprisonment is an act of restrain a person against their will in bounded area without any justification and consent. As we know, in law, we have criminal law and we have tort law. For false imprisonment in tort law, the action must be intentionally. What is bounded area? Bounded area, it can be a physical barrier such as a locked door or the use of physical forces to restrain a person. Also, it can be a failure to release or invalid use of legal authority. It will only be counted as bounded area if the freedom of movement is limited in all directions. If there's a way to escape, then the area is not bounded. But if the means of escaping will result in physical harm or the defendant threatening to harm the family, then the area is bounded. Element of false imprisonment. First, willful detention. Willful detention applies to intentional restraint in any form, including physical restraint a person from exit the bounded area. Second element, without consent. The plaintiff must acknowledge that there has been confined and did not give consent to the defendant. Example, a person grabbing another person without their consent and hold them so that they cannot leave. Third element of false imprisonment is without authority of law, that the defendant does not have any formal letter or warrant for the restriction. Example, an employer who detains a person for questioning for unreasonable amount of time for suspected theft. Now I will explain about defenses of false imprisonment. Defenses to false imprisonment claims often turn on whether the person claiming the imprisonment gave consent either or implied, or whether the person who confined another had a reasonable ground to justify the imprisonment. The first defenses of false imprisonment is voluntary consent. That is, a person or plaintiff who give consent to the confinement without any coercion or fraud may not later claim for false imprisonment. Second defenses is police privilege. The officer have the right to detain someone they have probable cause to believe has engaged in wrongdoing, or they believe the crime has been done. The third defenses is shopkeeper privilege. Every merchant has law to protect them from false imprisonment claims. These defenses allow merchants to detain retail patrons for a brief period of time when they have a reasonable grounds to believe that the person have committed retail theft. But shopkeeper is limited to detaining a person to verify the ID or hold the person in custody until the police officer is arrived. The last defenses of false imprisonment is citizen arrest. In some situations, a person who is not a law enforcement official can make a citizen arrest by calling the police officer when the crime is committed in their presence. But it doesn't mean to give citizens a right to take place of law enforcement. Action that follows is a damages in false imprisonment that flow from detention. A person injured by conduct, either knowing or negligence, is entitled to compensate for damages and has no duty to lessen the gravity of such damages. There is no legal rule for the assessment of damages, and it is left entirely to the court. The damages include physical pain, injury, mental suffering, loss of time earning, and interruption in occupation. Furthermore, nominal and compensatory damages. This remedies is the general rule for individual personal tort action that the plaintiff is entitled to recover an amount that will be just and equitable, justifying an award for exemplary damages in the absence of circumstance. But nominal damages only may be insufficient and flawed if the fact have proved that the right to greater damages. Third remedies is punitive exemplary and aggravated losses. If the imprisonment is reckless that affected dishonor, extortion, libel, and malicious manner, the jury may go beyond the compensation rule and causes exemplary and punitive damages to the defendant as punishment. Punitive damages are awarded in case that the defendant's conduct is grossly indifferent to the rights of others. Exemplary damages may be provided in certain circumstances when the power is misused by the state. Punitive or exemplary damages will not awarded if false imprisonment was brought in good faith, without malice in law and no element of oppression. Habeas corpus is considered as an effective remedy for immediately release from wrongful detention, whether in jail or in private custody by English law. Self-help. The plaintiff who has been detained unlawfully may use self-help to run with a reasonable force to protect themselves from unlawful arrest. The force used must be proportional to the condition. Self-help is a risky method because the arrest depends not only in the commission of crime but in alternative and a reasonable doubt. Therefore, if an innocent person finds a reasonable basis for their suspicions, then an innocent person who forcibly resists may be liable for battery.
Well, let me present about nervous shock. Nervous shock occurs where a person willfully does an act that is intended to cause physical injury to another, and that does in fact cause a reasonably forcible physical harm to them. There is two victims. First is primary victim. A primary victim is a victim who is directly involved in an accident and suffers injuries as a result of the fault of the tortfeasor. Secondary victim. A secondary victim is one who suffers nervous shock without him or herself being directly exposed to any physical danger in the accident to be primary victim.
Trespass to land. Trespass to land occur when a person directly enters upon another land without permission, or remains upon the land, or places any object upon the land. The only intent required for this claim is the intent to enter the property. This tort is actionable per se, that is, without the need to prove any damages. So, even if your neighbor accidentally crossed from their property to your lawn, it can be liable for trespass. Trespass to land also can be occurred by physical item such as golf ball. By contrast, nuisance is an indirect interference with another use and enjoyment of land, normally required proof for the damages to be actionable. First element, trespass to land must be intentional, that the defendant must either desire or know to a substantial certainty that they will be interfere with another right of possession. Next is enter. Enter is essential element of trespass to land. The defendant must enter the land without permission of the owner or a person that have possession of the land. First, trespass to the land can be occurred when a person enters the land. Second, refuse to leave after inviting onto the land. Third, causes another person enter the land. Fourth, an object enter the land. Fifth, fail to remove personal property from the land. Third element, land. Land is include the ground, the airspace above the ground, and the material under the ground. Also could be anything attached to the land, such as buildings and trees. The owner owns a certain amount of airspace above his property, which he can sue for trespass. Last element is possession. The land must be in possession of another person. It may be constructive or actual. Possession can be divided into two. First, possession in fact, that is the servant possession. Second, possession in law, that is master possession. The servant possession intention is to exclude others on behalf of his master, and he can maintain trespass action against those who interfere with the property, while the master possession is to exclude others from interfere with the thing, and he do that for his own behalf. Defenses of trespass to the land. First, legal authority. The defendant had a legal authority to enter the land, such as search warrant. License. License is the defenses that the defendant used for trespass to the land. License is the defendant had a license to be in the land or area, and this was not withdrawn by the plaintiff. Next defenses is to save life. The defendant trespassed the property in order to save life, such as saving the cat from a tree in the plaintiff's garden. To take back possession is the defendant entered the land to take back possession taken by the plaintiff that originally belonged to the defendant. These defenses can be dispossession, that is, wrongfully taking possession of land from its rightful owner. For dispossession, the prerequisite is the plaintiff must have possession. Second, the plaintiff should have a better title as compared to the defendant. The last defenses is abetting, that the defendant trespassed the land to end nuisance. For example, cutting off the tree branches that overhanging in your neighbor land.
We can refer to Tan Wee Chon versus Ong Pek Seng cases. The defendant used a path to reach their house from the plaintiff land. One day, plaintiff buy the land and fence it. The defendant demolished the fence. They argued in the court that the plaintiff has to prove damages since they are using the path for more than 40 years. Held, the action is actionable per se and did not require any proof of damage.
Next, remedies for trespass to the land. First, damages. The plaintiff can claim for damages in order to recover any financial losses suffered as a result in infringement, or a nominal sum may be awarded if there is no damages occurred. Second remedy is injunction, that the plaintiff may not want a financial compensation at all, but instead seek an injunction. That is a court order for prevent a continuing of future infringement, such as asking someone to remove his tree.
Nuisance is always connected with trespass, but actually there's have difference between nuisance and trespass. So let's see the difference. Nuisance. The meaning is unreasonable interference and also known as indirect harm to the land. For trespass is direct and intentional interference and the action is without any proof. Second, nuisance is indirect and can take place from outside property, while trespass direct entry into the property. Third, nuisance, who indirectly affected may sue by the plaintiff. That is mean the plaintiff can sue who that indirectly affected to their land. For example, Encik Ali was plant a tree in the area of his house, but the root of the tree had accidentally grown next to Mr. Dolah's house. For trespass, only for who that direct possession of land can sue. For example, Mr. Ahmad is the owner of the land in Klang, but one day there are people has overhanging the advertising billboard in Mr. Ahmad land. So Mr. Ahmad can sue the people charged under trespass.
What is trespass to goods? Trespass to goods is the direct and wrongful interference with another in the possession of goods or movables. Interference may comprise taking the goods or chattels from another, damaging them, breaking them, and even simply moving them from one place to another. The damage, loss, or interference must directly affect the goods themselves. The removal of goods which are later damaged is insufficiently direct for the purpose of liability. In trespass, liability and negligence may arise. Trespass to goods is based on interference with possession and not the title. A person in possession or with the right to possession may maintain the action. The person in possession of the goods can maintain trespass against all persons except a person with better titles. Title may derive from purchase from previous person with good title, manufacture, finding and taking from state of nature. The person with the better title may himself be in position to restrain and sue the possessor. For the wrongful holding of goods, the principle emphasizes the relativity of title to property. Defenses. That which would otherwise constitute trespass may be mandated by consent. The act must be within the scope of the consent. If the person exceeds the term of consent, consent is negated. Action may be justified by lawful authority. There are numerous statutory provisions which allow guardian and public officials to enter a property, search for and seize goods that may be evidence in criminal cases. Goods which are stolen, contraband, or are used in an unlawful enterprise may be subject to seizure under legislation. Legislation commonly confers power on the district court to issue warrants allowing for search and seizure. The warrants authorize entry, seizure, and removal of material. Typically, it gives an authorized officer power to enter, search, and take evidence. Generally, the evidence may be removed for the purpose of the investigation and retained pending the conclusion of the proceedings. Legislation may make provision for disposal of seized evidence in particular cases. Remedies. A person who detains goods may be subject to an order for their delivery and or may be liable in damages for their detention. He may be liable alternatively for their return and or for the value of the goods, together with the damages in either case. Where it is an ordinary item with no unique characteristics, the power to order delivery is discretionary. Delivery may not be ordered where the thing concerned is an ordinary item which can be replaced, has no particular value, provided that damages would be adequate. An allowance may be made to the defendant where he has done works or taken steps which have increased the value of the goods. Damages for conversion are generally the value of the item or chattel at the date of conversion. This is assessed in according with the general principles similar to those applicable in the case of the breach of contract for the sale of goods. Loss of rental value may be allowed.
First article is about two farmers charged with trespassing on Sultan of Johor lands. The fact is when Yen Fok Choi 64 has charge of trespassing on land owned by the Sultan of Johor and plead guilty at the magistrate court. The second farmer has been charged is Gan Tong Chon 62 charge of trespassing and another charge of hiring Indonesian worker without valid permit. The second article is about jail time and RM1000 fine for thief and trespassing. The fact is when Azmin has admitted to charge of thief, trespassing and impersonating and plead guilty to all three charges. The first is thief. Azmin was charged under section 318 of the Penal Code. Second, Azmin has been charged for impersonating a police office. He was charged under section 170 of the Penal Code. Third, Azmin also charged for house trespassing, that he was charged under section 448 of the Penal Code.
Last but not the least, let me present about the conclusion. Trespass can be faced by means of humans' innumerable instances in a day. But what is necessary is to, in reality, understand the nature of Trespass Act, property, laws, and influence of it on the plaintiff. If the nature of the act is itself suggestive of wrongful incidents, voluntary undertaken to constrain to enjoyment of the right to eliminate from the private property, then contrast of all possible resource to recoup the harm need to be recognized. Thank you.